intègre la gestion du risque. Il est clair que dans notre allocation de ressources, on fait des choix en fonction du risque. Par exemple, à la CNIL, nous avons un programme annuel de contrôle qui varie selon les risques principaux que nous identifions. Mais pour autant, une plainte reste une plainte. Et lorsque Max Schrems demande accès à Facebook de l'ensemble de ses données, il n'y a pas nécessairement un risque pour lui. He just wants to say. He wants to know, sorry. Donc, je crois que autant le risque est quelque chose de très utile pour les DPA, pour les entreprises, en termes de gestion de ressources, autant ça ne peut pas concerner la réponse à des droits. Parce que ceux-ci, je dirais encore une fois, existent, et s'ils existent, on doit répondre à ces droits, même si ce sont par exemple des plaintes sur le droit d'accès, même s'il n'y a pas véritablement de risque sur cette plainte-là.
Willem, did you want to comment on this? Because
only one remark. We are working with legal concepts, not only methods to assess, but also legal concepts. So the last word in the whole process shall be the word of the judge.
Indeed. Can we give perhaps a couple of questions to the audience? Anybody? 5 minutes, because we started a bit later. Sorry, I just can't see you at all, but there's some hands to my right. Sorry, David, I don't know what the microphones are, but here. So David, somebody else has the mic first. Just please bear with us.
Stephen Gardner, Bloomberg BNA. I just wanted to pin down the representatives from Apple a bit more, if possible, because if I understood correctly, you were talking more about security risks rather than privacy risks. So what I'd be interested in is to find out about your privacy risk assessment process and how you take into account the broader societal impacts or potential impacts of potentially privacy invading technologies. Thank you.
So I think part of it is, okay, I think part of it is just the limitations of the time. I don't know that the examples I see as being completely security. I think, and I know personally, having responded to plenty of regulators' questions about biometric data, that the security of any biometric data is directly a privacy issue. But there, and I'll keep this at kind of, I suppose, a higher level, but Apple, like many large firms, has a diagnostic data collection program that our users can opt into. And one of the roles that Jane's team and my team play is in doing review of that collection, not just to see that it fits within the consent that the user's given, but also that there is a direct business or engineering decision that's going to get made on the basis of that data, and that the data being collected is minimal to achieve that goal. So through techniques like bucketing or sampling, or just simply not collecting the data at all when it's not tied directly to the need that the engineering team is proposing. And so that's maybe a more traditional privacy sort of concern with data minimization, and it's also part of our internal programs.
Can I just add to that? Oh no, is it Jane, please?
Sorry, I just wanted to add one other thing. For a number of our products, like Maps and Siri, we don't attach that to an account at all. So we have a device-generated identifier that is used for communicating to the servers at Apple. There is no connection to your Apple ID. So we're trying to disaggregate the data collection and not actually attach it to an identified individual, your account, because we have no interest in creating a large profile of your use of our devices.
Can I just add to that to say that this is a journey in the sense that I've said this at the beginning, this is a new process. Organizations are not very adept, in my opinion, at this point, thinking about privacy risks and harms to individuals, and certainly it is very hard for them to think about the harms to society. That's not to say it will not be done, but we're on a journey. And security is an obvious place to start because everybody understands how security plays a role in the privacy. But of course, it's all about going beyond security, which I think you do. Anybody else wanted to? Question? David?
Yes, thank you. I'm a little bit surprised that the panel didn't say anything about the risk-based approach in the context of the proposed regulation. The UK in particular was promoting the use of a risk-based approach towards the new regulation, and so I'm just wondering if perhaps David Smith could explain the idea of the UK with regard to the proposed regulation. Thank you.
We simply don't have time, but please, David, go ahead. And Isabel, vite.
No, I'm not going to do an analysis of the regulation. I'll just say two things. The regulation is not settled yet by a long way. All we're seeing at the moment is the council developing its text, and there've got to be negotiations. So what will come out is far from clear. And what I think is a problem in applying the risk-based approach is whatever you do, it's saying it's businesses with less than so many employees are less risky, it's less than such a turnover, whatever it is. It's sort of better than nothing, but it's not really a risk-based approach, because a risk-based approach is based on all the factors that I've said, and it's not simply based on how many staff you've got or what your turnover is or whether you're a small or medium enterprise. SMEs who develop apps are just as dangerous in this world as some of the enormous companies that perhaps don't process very much personal data.
Isabel, do you want to make a move?
Yeah, I think I'm going now to speak in English because I'm afraid by David's questions, not David, yeah, David's question, and because I was planning to say a few words about that in my intervention, and it is introduced into the regulation with the accountability issue, and right now the discussions are around the idea to proportionate the accountability obligations to the risk-based approach. And as I said, right now the idea is that you are accountable to enforce all the accountability tools only for risk or high-risk treatments. And this is what I try to explain, where I see a problem, because you can, if you carry on along this road, empty out all the accountability principle through that, because you limit the accountability principle only to the high-risk or risky treatments. And I think it's not what we want. So there are discussions still running on this issue, and I hope the final set will be less extreme than what is at stake now.
Jakob, did you have a question?
If there's time, yeah. That my question would be, Bojana, you said selected to be effective, and I think that I'm not sure whether it comes from Richard or from Peter, by the way, but
okay, well,
I think that in the risk-based approach, selective to be effective is a very essential part of it. Now, Isabel rightly said that in the end, there's, so to say, three parties: the private sector, data protection commissioners and authorities, and individuals. And individuals, if they didn't care about the risk, but just use their rights, what's the surplus for business? Because you know selectiveness to be effective, maybe between the authorities and business there can be some contact in order to know how do you define more or less the risk base. But finally, if there's an individual who says, I haven't got the right, and damn you don't care, I don't care about risk, I want to get my rights the way it was given. What would be the reaction from especially the private sector on that?
David, do you want to kick off, and then maybe we'll get Joanne to comment as well?
I mean, it's very helpful because it just gives me an opportunity to clarify one point, because I think this point Isabel made it about rights is very important. These are rights, and the right of access is, is a fundamental right, basically, and you don't have to justify using that right. And I would say to businesses, you know, you have to respond to those people exercising those rights, and it's not a matter for you to calculate the risk or why people want it. Those are rights, and you should deliver them. But I do say, even though they are fundamental rights, when we come as a supervisory authority to make our choices, we still have to look at risk. Every time a business doesn't properly deliver a response to an access request, doesn't lead to full use of our enforcement powers. It can't do. Otherwise, we look proportionately. And if, as was said, it's about principles and it's about access to Facebook and Facebook are denying access, then that would score highly in our risk approach and we might well take action. Whereas if it's about, you know, one business took a little bit longer than it should do to respond, then it's much less likely to trigger action. But it's not an excuse for not delivering rights.
Joanne, do you want to? Yeah, I mean, would you apply risk-based approach in the context of the right of access, or would it be in the context of determining whether there is legitimate interest for processing, for example?
Really, you know, we don't use the risk-based approach for rights, actually. No. It's about use, right? I mean, the risk-based approach is about our use of the data, and is it congruent with why we collected it, right? In an innovative society, right? We know we collected it under, to battle fraud, in my example, right? But our fraud techniques have now changed, right? But we didn't spell it out specifically that the fraud technique has changed. We're still using it for the same purpose, but the technique has changed. We're going to disseminate it to a new party. We haven't gotten specific consent, if you will, because we're a disaggregated, commercial entity. We don't have a direct relationship with the consumer. We are disintermediated, if you will, by our banks. So we're a processor from a European perspective. So we're taking a risk-based approach by continuing to do new things with the data, right? So this is the risk assessment. We're going to use new techniques to battle fraud. We're going to give the indication of new types of fraud to new parties. But we would never not honor the basic fundamental rights of an individual for access to how we are calculating it, who we've given the data to, or what we've done with their data. So I don't think it's about a risk-based approach to deny the individual their rights. It's all much more based upon how we are actually using the data in this new kind of evolving big data world. So I think there's a difference, for at least for my company. Does that address your question? Okay.
MasterCard, we offer the right of access and rectification to our customers globally. And the risk-based approach is really about product development, as opposed to, in any way, we would in no way deny the fundamental rights that are set forth.
And because I'm a moderator, I have the last word. I hope I've showed you where I talked about calibrating and building compliance program based on risk, that it is all about the positive obligations, not the rights, not how you respond to access, deletion, right to objection. And just to clarify what Joanne has said, this isn't only to be done when you're using data. Risk-based approach is about the whole life cycle of information. From the moment of collection, you have to understand what risks and harms could there be because of what you're collecting, how you use data, who you share it with, how you transfer it abroad to third parties, how you destroy data. The risk and harm matter. So just to make clear, this isn't about use versus anything else, but it's actually a whole life cycle. And with this, I think I must not deny you coffee, because that's your human right. And thank you, my panelists, for interesting discussion. We will continue in Brussels at the Center workshop, I think. Thank you very much.
Thank you very much, panel 6. We'll meet back here at 22. So when you hear the ding-dong, please come back into the room. At the same time, the parallel discussion is continuing upstairs. So no change of venue for the next session. Panel 8 will be in the Barracuda room as planned, and panel 7 will be downstairs right here.